difference in prosecution, confrontation, and post-grant procedures like invalidation and litigation, which focuses on technologies in biotech, pharmaceuticals, and medicine. Today, she'll guide us to have a close look at what's been going on since we started our drug patent linkage system June the 1st, 2 years ago. She'll share with us what it looks like, basically a panorama of the whole system, how it works and what we've got, say the fundamental legislations and some milestone cases, and what we can take away, like some strategic thoughts and practical tactics for different players. The presentation will last for around 40 minutes. Questions are welcome anytime during the presentation. You may type in your questions and send them to us. All participants will be muted. We'll have a session of question and answers after the presentation. Get back to you with the answers and to answer questions online. Now, I'll hand over to Qianwen. Hi, dear, the floor is yours.
Hi, Ying. Thank you. Thanks for your warm introduction. Good morning, good afternoon, good evening. Welcome everyone to this webinar. We're so glad to have you here. I'm Wenyu. And today I'm gonna talk something about China's drug patent linkage system. And I wanna share with you some cases and have a discussion on a few important topics. And we'll be covering the following points. First of all, I want to begin with an overview of the system, including the framework, key elements, and how the system is currently running. Generally, the patent linkage system has built a connection between the marketing approval of generic drugs and innovators' drug patents. The system involves a series of procedures, including patent registration and disclosure, generics application and declaration, dispute resolution before the patent office or the court, approval stay period, and the first challenge award. As the basis of the framework, the MNPA has set up an online platform called China Patent Information Registration Platform for marketed drugs, which is maintained and overseen by the MNPA Center for Drug Evaluation, also called CDE. And this is a screenshot of the platform page. And first, you can see a search box here, which provides a quick way for people to get the information of the drug or patent they're looking for. And below, there are 3 function module entrances: patent registration, patent information publicity, and patent certification. And you can click on each of the modules to open the corresponding module page. The patent registration module is for MAHs to list patent information on drugs registered and marketed in China. The MAHs can list the information on the platform within 30 days after receiving the marketing approval. After that, if any related information is changed, it should be updated accordingly by the registrant within 30 days after the change takes effect. Listing of patents is not mandatory, but unlisted patents will not be eligible for the linkage system, which means you have to wait until the generic drug is marketed to resolve the dispute. Well, another thing to note here is that not all the patents related to the new drug are eligible for the linkage system. The categories of patents that can be listed are also provided. For chemical drugs, patents that can be listed are those for API compounds, patents for API containing pharmaceutical compositions, and patents for medical uses. For biological products are patents for API sequence structures and medical uses. For traditional Chinese medicines are composition patents, extract patents, and medical use patents. And it should be noted that the categories do not include patents on intermediates, metabolites, new crystals, preparation methods, and testing methods. And also, the MAHs are responsible for the authenticity, accuracy, and completeness of the listed information. The next is the module of patent information publicity. This module is set for the public, especially for generics, to search the listed patents of reference drugs. And in this module, you can browse the published patent information by 3 different categories: chemical drugs, biological products, and traditional Chinese medicine. Or you can also search the database to retrieve the information you want. And now we come to the third module, patent certification. This is used for publishing the generics applications and related patent statements. When a generic applies for marketing, it should make a statement for each relevant patent of the reference drug. Specifically, the statement is classified into 4 categories. Category 1, there is no relevant patents listed on the platform. 2, the listed patent has expired or has been declared invalid, or the generic has a patent license from the patentee. Category 3, there is a patent listed, and the generic will not market the drug until expiration of the patent. And Category 4, there is a patent listed on the platform, but it should be invalid, or it does not cover the generic drug. If a Category 4 statement is made that the generic drug does not fall within the scope of the relevant patent, together with the statement, the generic applicant should also provide a chart comparing the technical resolution of its generic drug and, well, the relevant claims of the listed patent, and also relevant technical data as supporting materials. And then, within 10 working days, the CDE will publish the generics application together with the statement on the platform. Now let's take a look at the marketing approval process of generic chemical drugs. For Category 1 and 2 statement, the NMPA will make approval decisions based on the conclusion of the technical review. For Category 3 statement, the generics applications that pass the technical review can also be approved immediately, but they cannot launch the market until expiration of the patent. For applications filed with a Category 4 statement, if no opposition is filed by the innovator within 45 days from the date the generics application is published, the NMPA can directly make an approval decision. The approval decision. And in this scenario, the generic can seek confirmation that its product does not fall within the scope of the patent. In the other case, if the innovator holds an objection to the statement, it should file a lawsuit to the court or request confirmation by the Patent Office within the 45-day time limit, and then notify CDE within 15 working days after the case is instituted, which will trigger a stay period of up to 9 months at CDE. The stay period will be ended if the two parties come to a settlement, or if the patent is invalidated, or if the generic drug is confirmed not to fall within the scope of the patent, or if an effective ruling by the court or a decision by the Patent Office is not yet available over the 9-month stay period. If the generic drug is confirmed to fall within the scope of the patent, the generic application will not proceed to a final approval by CDE until approaching the patent expiration date. And it's worth mentioning that the first generic chemical drug to successfully challenge the innovator's patent can enjoy a generic drug exclusivity of up to 12 months. So that's the approval process that a generic chemical drug may go through. For the process, well, there are also some key points to note. First, as you may have noted, a dual track system has been set, which means you can go to the Patent Office or the court for the resolution. And the Patent Office has set up a separate board specialized in handling such cases. If you choose the Patent Office, make sure that there is no duplicated case instituted with the court, and the claims at issue remain valid, and one petition is filed against one solution and one claim only. Otherwise, the request will be rejected. While for the judicial route, Supreme People's Court has designated Beijing IP Court for the first instance. And also, it is provided that the court will not suspend the litigation on the ground that the same case has been accepted by the Patent Office, and in general, will not suspend the litigation on the ground that the invalidation request of the relevant patent is accepted by the Patent Office after the institution of the lawsuit. Also, the court applies the res judicata doctrine, which means that in general, early resolution rulings or judgments by the courts are precedential unless evidence opposite. And well, as I've just mentioned, the innovator will trigger a stay period of up to 9 months, which starts from the date the case is accepted by the Patent Office or the court. During the stay period, the CDE will not stop the technical review, but it will suspend the approvals until the decision is issued by the Patent Office or the court. If the drug is confirmed to fall within the scope of the patent, the marketing approval process will be held off until expiration of the patent. And it should be noted that the stay period for the same generic drug is set only once. The next thing important is the first challenger word. To incentivize generics to seek early entry, China gives a market exclusivity of up to 1 year to a generic that is the first to challenge and succeed in invalidating the innovator's patent and the first to put the drug onto market. During the exclusivity, the CDE may review, but will not approve other generics applications. This exclusivity period will not exceed the term of the patent being challenged. The next point is the different handling of biosimilars and TCMs of the same name and formula. Unlike generic chemical drugs, well, there is no stay period for first challenger word for biosimilars and TCMs of the same name and formula. The CDE may approve directly based on the conclusion of the technical review. So, it seems that patent linkage system for biosimilars and TCMs of the same name and formula is currently incomplete, and we expect this part to mature over time. We made a comparison between China and the United States for the approval process of generic chemical drugs. And first, as I've just mentioned, China has set a dual-track system for the resolution. Patent office and court both are the options. While in the United States, innovators had to file an infringement suit in federal court against generics. And also, different from the artificial infringement doctrine in the United States, the Chinese patent law does not take the marketing application as an act of infringement. It provides that if a patent dispute arises during the generics application, the involved party may seek confirmation of whether the generic drug falls within the scope of the relevant patent. The time limit for the innovator to sue or petition is 45 days in both China and the United States. The stay period of up to 9 months in China is much shorter than that of 30 months in the United States. The exclusivity of up to 12 months granted to the first successful challenger in China is much longer than that of 180 days in the United States. As you can see, in some key points, there are differences between China and the US. China has built this system based on its own national conditions and practice. And now let's take a look at some cases that I think can represent some of the key scenarios. First, we can see that there can be an invalidation procedure in parallel with the case. And well, generally, there will be no suspension of case at the court or patent office if a party requests invalidation of the patent. However, in the event that the patent office has made a decision to declare the patent invalid, but the decision has not taken effect, the court and patent office may make different moves. It has been clarified by the patent office that if the patent is partially invalidated, the patent office will proceed with the remaining claims. And if the claims are declared invalid, all of the claims are declared invalid, then the request will be rejected. However, there are currently no rules for the court. So, considering the similarity between patent linkage litigation and infringement cases, it has been speculated whether the court will follow the same criteria as for infringement cases. That is, the rule to dismiss the action first and initiate a separate action if the decision of invalidation is set aside by an effective administrative judgment. So, dismiss or continue. Currently, we see that the court has taken different actions for two particular cases. In the case between Chugai and Haihe, after Haihe submitted generic drug application against Chugai's originator drug, aldacalcidol, with a Type 4.2 statement, Chugai, as the patentee, filed a lawsuit with Beijing IP Court. At the same time, an invalidation procedure initiated by two third parties was ongoing. Before the court made a first instance judgment, Chugai's patent was declared invalid by the Patent Office. Given that both parties requested a substantive trial, the court conducted substantive trial and made a first instance judgment, finding that Haihe's drug does not fall within the scope of Chugai's patent. And then Chugai appealed to Supreme People's Court, and the SPC upheld the first instance judgment. Well, differently, an example of dismissal comes from the case between Sumitomo and Huahai. After Huahai filed generic drug application against Sumitomo's originator drug, Lurasidone, with a Type 4.2 statement, Sumitomo, as the patentee, filed a lawsuit with the court. At that time, Sumitomo's patent had already been declared invalid by the Patent Office, but the decision has not yet come into force. Sumitomo advocated substantive trial of whether Haihe's drug falls within the scope of its patent, but Huahai disagreed. The Beijing IP Court made the first instance civil ruling, and Sumitomo's claim was rejected. The SPC upheld the ruling in consideration of the interests of both parties and the purpose of the linkage system to resolve disputes in the early stage. For both the cases, we can see that the situations were similar, but the court made different choices. And after comparison, we can see that for cases where the patent has been declared invalid, but the legal status of the patent has not been finally determined, the unanimous consent of both parties to continue with the substantive trial is a major driving force for the court to proceed. Another point is that we see in patent linkage litigation, the principle of estoppel and the principle of donation are applied. In the case between Chugai and Haihe, Chugai, as the patentee, made amendments during the procedure of invalidation to limit the antioxidant in Claim 1 into a specific type, DL-alpha tocopherol. According to Haihe, the antioxidant used in the generic drug is not DL-alpha tocopherol, but one of the antioxidants disclosed in the description of the patent. The first instance court determined that the antioxidant used in the generic drug is not an equivalent feature of the tocopherol based on the principle of donation, and the SPC came to the same conclusion by applying the principle of estoppel. In another case between Merck and Qilu, it was found that during the patenting procedure, Merck, as the patent applicant, limited the percentage of surfactant in Claim 1 into a specific endpoint value of 0.5 weight percent out of the 0 to 3 weight percent range described in the description. And It stated that this technical feature is particularly useful for solving the technical problem of the patent. And given that, the Beijing IP Court held that based on the principle of estoppel, any percentage of surfactant other than 0.5 weight% has been abandoned by the patentee. And based on the principle of donation, the technical solutions comprising a surfactant in the range of 0 to 3 weight%, except 0.5, have been donated to the public. And for the determination of the technical solution of the generic drug, well, during the trial of the case between Chugai and Haihe, Chugai suspected that the prescription submitted by Haihe was different from the actual one being manufactured. The SPC opined that when judging whether the technical solution of generic drug falls within the scope of the patent, the application data submitted by the generic should be used as the basis for comparison and evaluation. Whether the technical solution actually implemented by the generic is the same as that described in the application is generally outside the scope of trial to confirm whether the generic drug falls within the patent scope. Another patent linkage case showed that it will be first determined whether the patent covers the innovator's drug before determining whether the generic drug falls within the patent scope. If the patent does not cover the innovator's drug, it should not be listed on the platform in the first place. And if it has already been listed, the court will dismiss the case. So, for this system, currently, there are some considerations of practice and also strategies for innovators and generics. For innovators, well, I think there are some points worth noting. First, to register or not, well, in my opinion, for innovators, you can list patent information on the platform, but the listing is not mandatory. And you can decide whether to do the listing or not based on your own commercial planning and strategies. However, it should be noted that unlisted patents will not be eligible for linkage system, which means that you cannot resort to linkage to solve disputes early or to prevent or delay the marketing of generic drugs. So, to register or not, it's worth thinking about. And the next thing is what patent to register. As you can see, the generic drug exclusivity of up to 1 year is quite incentive for generics to challenge. So you want to be mindful in selecting certain patents to be listed while keeping others away from Category 4 challenges. And another suggestion is be prepared in advance. Well, for innovators, you want to keep a close eye on generics applications. Be prepared in advance to defend your listed patents and to move quickly when necessary. Of course, it will be critical to have on-the-ground advice from Chinese Patent Council about legal and practical strategies in any given situation. So, if you need any consultation or advice, we'll be pleased to help. We also have some suggestions for generics. First, to find and target. If you want to enter market early, you can lock in the targets as soon as possible through, for example, due diligence to analyze the stability of the listed related patents. And when there is sufficient evidence, raise patent challenges in a timely manner to move the obstacles in the way. Generally, an invalidation challenge moves quickly and can be concluded in about 5 to 6 months' time. And the first successful challenger can enjoy a market exclusivity of up to 12 months, which is surely a huge advantage. Another suggestion is to take action proactively. For Category 4 statement, if the innovator does not take action within the 45-day period, I'd suggest the generic move to the court for ruling that your generic drug and application does not fall within the scope of the patent. As I've just mentioned, the court applies the doctrine of res judicata, and this can prevent the innovator's attack, or for example, by filing an infringement lawsuit after the generic drug is marketed. And so this is the linkage system in China and how it is currently running. Well, as you may have noticed, besides this system, other systems are also running or developing in China. For example, we have already introduced BOLA exception, and we have a proposal of data exclusivity under consideration. And the new patent law has also introduced BTE as a compensation for new drugs. So it is believed that the whole framework will be refined and improved gradually in practice. If you like further details or updates, or if you need advice or support, feel free to contact us and we'll be glad to help. That's it for today. Thanks for your attention. And now I will open the floor for any questions you may have.
Okay, thank you, Wenyu. Okay, thank you. Thank you for your sharing. It's quite informative and I think very practical. Now it's our session for questions and answers. Please type in your questions and send them to us. If we cannot finish them or them in this session, we'll reply offline by email, definitely. Okay. Good. This is a question from Mr. Ray Wilson. Thank you, Mr. Wilson. The question is, if the market approval holder, if the holder is not the patentee, can he or she list the patent on the platform?
Yeah, well, thank you. Well, thank you for your question. You mean if the MA holder is not the patentee, right? According to the measures issued by Patent Office and the MNPA, it is the MAH to list patent information on the platform. And if the MAH is not the patentee, an authorization from the patentee is needed.
Okay, let me see. Okay, we have another question. is from Miss Catherine Cooper. Thank you, Miss Cooper. In order to kick off the stay period in the drug administration, how to choose between the patent office and the court?
Yeah, thank you. Well, you've raised a very good point. Well, how to choose? Well, first of all, whether you go to the patent office or the court, as long as the case is accepted, it can trigger the stay at the CDE. And then what are the advantages or disadvantages of choosing the patent office or the court for the resolution? Well, this is also what we have been observing. And I would say that the patent office would be more efficient, because you see the patent office has set up a separate board for handling such cases. Well, and also this decision from the patent office would be enough for the city to decide whether to proceed or not. But if you choose the patent office, one thing to note here is that the patent office will not accept a case if there has been a lawsuit at the court in parallel. Well, for the judicial approach, well, it can be time consuming, considering, well, you know, the current backlog of cases at the court, and also you need to wait for the judgment to take effect. But there's also advantages. For example, it is independent well, of the parallel case with the patent office, and an effective judgment is more final than the patent office decision. So you can see that there are always pros and cons, and you need to weigh between them. So I would say that if desired, you may first go to the patent office, and after the case is accepted, file a lawsuit with the court. Yeah. Thank you.
Thank you. I think it's about the last one. Yeah. Okay. Thank you, Mr. Brian Campbell. The question is, how would the innovator be noticed of the paragraph 4 statement?
Oh, thank you. Thank you. How be notified? Thank you. Well, that is a very interesting point, because according to the regulations, first the statement will be published on the platform after the generics application is accepted, and secondly, the generic applicant should notify the innovator of the statement. Well, according to the contact information of the innovator registered on the platform. But as you may have also noted, the current regulations do not specify the consequences if the generic does not notify the innovator in a timely manner. So, in my opinion, I would suggest innovators to pay special attention to the information published on the platform, to get the news as soon as possible. Yeah, thank you.
Thank you, Wenyu. Okay, I think it's about time here today. Thank you very much for your attentions and participations. And we SPTL is devoted to bring you the latest news, events, and the trends of IP products in China. Hope to see you next time. Bye bye. Have a nice day or a nice dream.
Bye. Thank you.